Hello, I'm Dr. Len Bear. Today is Sunday, July 16th, 2023, and this is Targeted Justice v. Garland podcast. It's a podcast about an extraordinary lawsuit, and this is a week 29 update. This will be an episode you're not going to want to miss because of what happened this week in the legal realm of the lawsuit. But first, let's say hi to our guests. First and foremost, a fearless human being, a David who challenged an ever-powerful Goliath, an intellectual heavyweight who sees through the games the deep state is playing, our most precious human asset, Ana Toledo. Hello, Ana.
Oh, thank you, Len. That's so pretty. Thank you. Good morning.
Good morning, Ana. This is every time I'm looking forward to introducing you in some other way, and it comes so easy because you truly are an invaluable asset for all targeted individuals and for all Americans, because this lawsuit touches everybody. And our special guest today, Gary Walderman. He is an ally to targeted individuals. He's not a targeted individuals. He's a podcaster and it's empathic human being who makes his position know that injustice inflicted upon targeted individuals will not be tolerated. Gary, welcome to the show.
Thank you, Len. I appreciate it.
We are happy to have you. Let's get to the legal update. It's a long-awaited legal update because there's some important things happen in the lawsuit. So let's get to it. Ana, please.
Yes, actually, before getting into the lawsuit, I want to congratulate Len because he is our newest member of the board of Targeted Justice, and we're so proud to have him because his work and his commitment and his resilience fighting for this is just superhuman. And so we want to welcome him, and everybody just send him messages of, oh, congratulations. Yes, we waited for this moment for exactly 6 months because it is very curious that the decision in the case was issued exactly 6 months after it was filed on July 11th. As we had anticipated, it was a possibility that the case could get dismissed and we had to go to Fifth Circuit Court of Appeals. So I had already applied for my good standing certificate from my originating U.S. District Court, which is Puerto Rico. And even though I'm admitted to Southern District of Texas, obviously. So I already had it in my desk waiting for it to be sent along with my application for admission to the Fifth Circuit. So it wasn't like I had to run and get all nervous about getting it on time. And the day after we got the judgment, I filed the notice of appeal before the Fifth Circuit. So in that sense, our backup plan is working so far. And I want to, I have been doing all this week, I've been going into the conference calls, the TI conference calls. And I have to say, thanks to everybody because the support is amazing. And it is not about me, but it's what I see in the community, which is that the TI community has come together and in an act of empowerment. And because this is the hope, this case brings hope to all of us to be free. But I'm going to go into the discussion of what happened. The judge, the court in this case, issued a memorandum and order, signed a memorandum and order dismissing. It's the first time I see something like this where it's not only dismissing everything, because plaintiffs usually have the court grants them an opportunity to make an amendment if they deem it necessary, but it's like dismissing everything except for some little Privacy Act claims, and then just never ever file again with prejudice, One of the things that stuck out at me was that 4 documents are not mentioned in this memorandum and order, which are the 2 oppositions that plaintiffs filed to the motions to dismiss. They're not discussed at all. And the discussion on the motion to compel, the limited production on the discovery, as you know, we requested the court to order the FBI to produce the status of plaintiffs on the TSDB. It's the minimum that could have been done because that's a list that's under their control. However, the court, aside from saying that it has bizarre and incredible allegations, which it's very uncharacteristic in this context, it also says that they do not allege that the plaintiffs had to prove at a pleading stage, which is not accurate, to prove that they had seen the list, had access to the list, and how come they haven't produced it? Well, that's exactly what plaintiffs were asking for. There are 2 levels of when you file a lawsuit, a court is supposed to accept as true all the well-pleaded facts. And in particular, the Supreme Court has says that Rule 12b-6 does not countenance dismissals based on a judge's disbelief of a complaint's factual allegation, like in this case, that she put in quotation marks the words directed energy weapons, as if it was a myth. So the Supreme Court has also said that asking for plausible grounds does not impose a probability requirement at the pleading stage. It simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of illegal acts. Well, the first part of this lawsuit, up to page 74, the Second Amendment complaint, has enough facts as to completely uncontroverted about, the fact that admitted by the FBI in a statement under penalty of perjury, innocent civilians are being placed in a terrorist screening database for other purposes. Then we have the sworn statement by Mr. Robinson saying that that's a secret criteria used for putting people on this list. Then you have the whistleblowers. One of the interesting things is that the court refused to take judicial notice of the congressional testimony contained in a congressional report, which is susceptible of judicial notice, about how supervisors at the FBI benefit economically from $30,000 to $50,000, depending on the amount of people they can classify as domestic terrorists. What Mr. Friend didn't say, and I think it's really, he didn't say, is that classifying somebody as a domestic terrorist, really what it means is to be placed on the terrorist screening database, which is distributed throughout the nation and throughout 60 countries. And in the nation, last count I saw in the internet is 74,000 entities and persons. However, I did include in the lawsuit the sworn statement information that it is given to 18,000 law enforcement, tribal, federal, and state agencies, 1,440 organizations, and 536 corporations. The biggest corporations in the United States, such as CVS, Kroger, Airbnb. So more than 1 million people get this information, including, in the fusion centers when they send out these people. It is my position that even a non-targeted individual could file this lawsuit for declaratory judgment because it is the arbitrary, capricious inclusion of innocent civilians on a list that constitutes government defamation. So in the decision, the court does not go into discussing this illegality, despite of the fact that one of the claims, aside from the declaratory judgment, to declare illegal the practice of putting innocent civilians on a terrorist database, when Homeland Security Presidential Directive number 6 stated that only known and suspected terrorists could be placed on that list. This is a huge violation of the Fourth Amendment, that you cannot, unreasonable searches and seizure, because it is a seizure of the person to include them on a list. that they don't belong to because they don't have probable cause to be there, which is the reasonable grounds standards that they supposedly use to place people on this list. I mean, I could read many of the paragraphs here for that clearly establish that the allegations are neither fantastical nor bizarre. For example, defendant FBI Ray and Cable know that people, including in handling codes 3 and 4, which is where the non-investigative subjects are placed, do not meet terrorist criteria, yet under color of law continue to illegally maintain plaintiffs hostage under those categories in open violation of their constitutional, substantive, and due process right. Do you hear anything bizarre or fantastical in that allegation? It's a pure argument. It's a pure statement of fact based on the Constitution. And so are the first, 74 pages, as I have mentioned on many occasions. I did a copy and paste. This lawsuit, most of its paragraphs are direct copy and paste from news articles, admissions by the FBI, admissions by the DOJ. Most of it is based on audit reports prepared by the Department of Justice that conclude that this list is being badly managed, including, which the court didn't want to take judicial notice of, that the FBI field offices nominate people to this list without complying with agency regulation. That is a huge violation of the Administrative Procedures Act. However, the court didn't want to look into it. So I feel confident that we have a very good opportunity for appeal, and even grateful to the fact that the court didn't grant a hearing, because here's what happens when we go now to the Court of Appeals. The review is what they call de novo, the standard of review, because the court didn't hold hearings. The court didn't have to do an evaluation, an assessment of the credibility of any witness. So usually Court of Appeals defer to the criteria, to the appreciation of the evidence by the lower courts. This didn't happen in this case. So it facilitates it, makes it faster for us to go on appeal. There are many things about this case that I think will be disturbing to the Court of Appeals, such as that not even a scheduling order was issued when the case was transferred to Houston. That's not normal. And there are other things too. The fact that none of the motions would be ruled upon on time. So I am confident. I really appreciate the support from everybody that has been listening in. One of the important claims we asked for was for the court to order Ray and Cable and DOJ and FBI and everybody to comply with the Constitution and the law. And that is not even discussed in the memorandum and order. So it is my hope that the right of petitioning for redress of grievances that is guaranteed in the First Amendment will be honored, and that we get to, we get this decision reversed, because it's very unfortunate, not just for targeted individuals, but because of the precedent it sets for all Americans. And the two documents that the court, the two motions that the court didn't want to take judicial notice of, this is very important, is number one, the whistleblower's testimony, which is so relevant to this case. And number two, the memorandum on state secrets by Eric Holder. That is totally relevant because it proves the misrepresentations made by the individual capacity defendants in their motion. There is such a thing as a Rule 11 under Federal Rules of Civil Procedure that regulate what attorneys, when an attorney signs a document, they are attesting that to the best of their knowledge, it's correct in all of its parts. And and this memorandum from Eric Holder totally disproves that defendants attorneys did that. I also wanted to mention that, you know, the TransUnion case, which is so important and relevant to targeted individuals, well, the court said, oh, it doesn't apply here. It doesn't apply here because they haven't proven that they have the list, which I'm not going to comment, but that TransUnion clearly says if you are erroneously classified as a known or suspected terrorist and that information is disseminated, it is presumed that you have sustained an injury. In fact, I don't know how the court in this case concludes that that doesn't apply to targeted individuals, because that is the gist of the matter here, and it's a purely constitutional, open, you know, black and white issue. That's pretty much, I'm going to be working. Like I said, I already filed a notice of appeal. I'm going to be calling tomorrow because I haven't received the docketing of the case, and I should have received it. So I'm going to be calling tomorrow. I'm going to be telling you whether there's going to be, the hearings are going to be in person or through Microsoft Teams, which was the last one I did before the First Circuit was through Microsoft Teams. So we'll keep everybody posted. I will have on Tuesday a conference call with Goji that we're going to explain to people how to write to these publicly traded companies that own and operate cell towers, to identify weaponized cell towers, to take pictures of them and to send letters to them under Securities Exchange Commission Rule 10b-5, which states that the directors have to inform their shareholders of any situation that may hamper, reduce the value of their shares. And so I'm going to be in that call, and I'm going to be explaining to everybody that calls in how to, and we're going to have examples on the page, how to send these letters, because this case is an important part of ending targeting, but we rely on this community for the grassroots organizing and the empowerment. Every morning, I repeat to everybody, you have to wake up in the morning and say, what am I going to do today to end my targeting? And that is going to move mountains. That is going to make the difference. So I really urge you to start this letter writing campaign that we're going to start on Tuesday. Len?
Very good. Thank you very much for this update. To summarize what you just said is that the judge granted the defendants their motion to dismiss our case, and now we're moving to the appeal state, and the appeal will be made in the Fifth Circuit of Appeal. Sorry, I can't speak right now. And so I was not aware of how the appellate courts work, so I prepared some slides that I would like to share with you to educate myself and our listeners about what these courts do and how they operate. So we're going to talk about the Fifth Circuit. U.S. Court of Appeals for the Fifth Circuit. It is one of the 12 courts of appeal that sit right just below the U.S. Supreme Courts. Organized regionally, these 12 courts are organized regionally, and the Fifth Circuit has jurisdiction over the states of Louisiana, Mississippi, and Texas. So this is how we ended up in Fifth Circuit, because we filed in Texas. The court is located in New Orleans, Louisiana, and it has 17 active judges, with a chief judge, Priscilla Richmond. How does that, is that accurate information so far, Anna?
Yes, completely. And it's, I might add, it's one of the most, it's well known for adhering to the Constitution. It's a court that is a defender of the Constitution and the Bill of Rights.
Which is truly encouraging. Next slide. So this is how the Court of Appeals operate. They do not hold trials, but they review decisions of trial courts for errors of law. Only courts with the original jurisdiction hold trials. So in this case, it would be the Houston District Court or perhaps the Victoria District Court. And I will ask you, Anna, about that distinction, because we originally filed in the Victoria District Court, and then for some unknown reason, it was moved to Houston. Both parties file briefs, which is a written legal document, and sometimes oral arguments are permitted. But during this oral arguments, only the attorneys for the plaintiffs and the defendants are allowed to speak to the court during that event. Each case will have a judicial council that consists of the chief judges and the equal number of circuit and district judges, which means that the minimum number of judges would be 3. Perhaps it could be higher. Anna, do you have any anything to comment on this information?
No, only that, I mean, it's really, it's really challenging because the people that are up there usually have, very privileged minds. So it's a great intellectual challenge, and I love doing it, and I love preparing for it, because I think it's the favorite thing I've enjoyed out of my entire law practice in terms of going to court.
That's wonderful. I would like you to address the difference between the courts in which we filed originally, and then and the court in which we received a dismissal. How does that play out? And if it's a part of our strategy, I don't want you don't have to say anything. You can just say no comments. But I am curious, because we know that we were moved from one court to another,
And nobody asked for it.
That's true.
That I hadn't seen that before. There is a precept in federal courts that the forum that plaintiffs choose is to be respected. 3 days after I filed the amended complaint, the case was moved to Houston. I believe that I had to add some language. I filed a complaint. I went to France. I filed a preliminary injunction, went to France. And while I was in France, they granted the extension for the preliminary injunction. And so when I came back, I did get I'm not kidding. I did get like dreams or whispering to my ear. So I amended the complaint to include additional language, and basically reorganized it to make it more cohesive. And so 3 days after I filed the new and improved amended complaint, the judge, on its own volition, ordered moving the case to Houston, even though nobody asked for it, as I said, and even though it was appropriately filed in Victoria. So that's one of the things that we're gonna be looking at in the appeal, aside from the fact that this case calendar was not like a normal case. We didn't have a scheduling order issued. The motions were accumulated and not decided until the very end. The motion to compel discovery would have, in a fact-finding process, it's essential. I would have thought the court wanted to know the status, the TSDB status of the plaintiffs. And The court instead said that, well, plaintiffs don't know if they're on the list or not, which two of them definitely do. And the others definitely do, but we don't, as an attorney, I cannot allege they know they're on the list because they haven't seen it. And that's my signature under Rule 11. I would be sanctioned. And that's why the plaintiffs did Privacy Act requests, because they did their due diligence to get the most information possible prior to filing the complaint, so that it would contain the most accurate statements of fact. And that is what, 80% of that lawsuit, as I have repeated all the time, is that comes from government documents, from official testimony under penalty of perjury. This list has not stopped a single act of terrorism. And that is something we have to start getting out there to the public. This list is a mechanism to suppress opposition and to deter whistleblowers, because whistleblowers know, like Mr. O'Boyle said in Congress, the FBI will crush you. And that's exactly what it's for. Don't you dare denounce corruption. Don't you dare denounce your neighbor doing something improper, because if your neighbor has appropriate connections, you will end up on this list. And it is un-American. It is completely opposite to our freedom rights. And so we want to, this week, I was in a program and I explained to people, many people are on the list. They don't know that they are on the list. We need to stop the narrative of, of all the, the nomenclature that TIs use. And we have to start talking about, when you bought a fridge, it got to your house with a dent on the door. When you had a duplicate credit card charge or withdrawal from your ATM machine, and you just don't think anything of it. But you know what? It's probably that you're targeted and you don't even know it, and you're getting slightly microwaved at night. I'm telling people to do the cupping of their ears exercise. You cup your ears after 30 in a silent place, after 30 seconds, maybe a minute, you will hear these very light pops. Those are microwave pulses. You can do it, in the privacy of a bathroom, so you don't, and nobody thinks you're crazy, like they're trying to imply, there are 300 to 400,000 Americans and 6 million people around the globe that are being tortured by the United States Space Force. This has got to stop. Congress has got to stop the funding. We're not going to stop fighting this judicial channel, but I ask that now more than ever, TIs continue in their activism, peaceful activism, because I think we got, and you might agree with me, we got the attention of the public, right? Since this complaint was filed, all of a sudden people are talking about somebody being targeted, right? Len.
Right. Yeah, I'm encouraged by the fact that it is slowly becoming a part of the public discourse. And our special guest today is a perfect example of somebody who is not a targeted individual, but has been exposed to the phenomenon of targeting. And I would really like, Gary, for you to address your personal intellectual evolution about this phenomenon. Gary?
Okay. I don't remember exactly when I heard about it. It has to have been 10 years, something like that. I feel like I've known about the possibility of targeting for quite a while, but I saw the amount of people who were at least publicly complaining that something was happening. I saw that just keep growing. And I have not done a ton of research into it, because on the surface of it, even when I first looked into it, it looked like it's very covert. It's very well protected. It's very high ups apparently don't want this information to be out. And that's what I got just from everything I looked at, everything that I sort of ingested through social media. And kind of pairing that with, and I don't consider myself a truther by any means. I feel like that label has been very tarnished, and people have been put into groups, and that group has been very, very much attacked over the years. So I don't really put labels on myself. I just keep an open mind and try to remain rational when thinking about the things that present themselves. But one of the things that I feel pairs with what targeted individuals face is the term conspiracy theorist, which came out something in like the 1960s or something, apparently created by the CIA, I believe, as a means to discredit anyone who is attacking those who have the means and the power to defend the attack, right? And at the same time, I feel like schizophrenia itself is very much related and linked to the targeted individuals phenomenon, possibly completely caused by it. I'm to the point now where I don't know. I feel like most of the problems we have in this reality are manufactured to some extent. Just like, somebody smacks you over the head and then the guy right next to him sells you the cure for your broken head, right? Like they're working, it feels like they're working together in general with most of the major problems that we face in this reality. And it's worked really, really well. As far as I can tell, like when I saw Havana syndrome hit the public circuit, I thought, well, this may be, maybe the public will at least believe some of it, that something may be happening to people, because it's clearly happening to these political representatives, and they're accepting it, right? Like the public itself is accepting that something was happening to these people. So it's not very much of a stretch to say this may be targeting someone else besides public officials, right? As far as like where I feel like it's going, I think it's promising that somebody is actually working on legal representation. That seems to be moving along. I wanted to ask you, Anna, do you feel like this is one of the first cases where an actual case is being presented and it has a chance of getting more acceptance from the public at large and the court system itself? Do you feel like that this is one of the first ones, or have there been cases in the past where they've just been completely thrown out and everyone is crazy type of thing?
Exactly. That's exactly it. When I was doing the research for this case, I noticed the pattern. There's hundreds of cases filed in federal court, and I assume many in state court as well. And they were all dismissed, alleging exactly that these are mentally unstable people, that this is, the difference of this case from those cases is that we are attacking the constitutionality of the actions of public officials, of including private individuals that are non-investigative subjects that don't meet this probable cause, which is the standard to put them on the list, and they are indiscriminately placing people there. So the difference of this case and the hundreds that have been dismissed is that it is based on uncontroverted facts, admissions by the FBI. There is an FBI former terrorist screening center deputy director admitting under penalty of perjury that innocent civilians, people that don't meet the terrorist criteria, are included in this list for other purposes. There's nothing more un-American than that, okay? And since they don't represent a terrorist threat, I almost know it by heart because I have repeated it so many times. And because they don't represent a terrorist threat, they are never stopped at airports for screening. What this means is it is kept away from them, but it is spread everywhere. And a lot of targeted individuals have been entrapped into crimes that they either didn't commit or they were just pushed into it. And because they didn't know the law, they were pushed into it. The wellness checks, they send police to your house to see if you're well, and next thing you know, you're in an ambulance and they put you in a mental hospital. This is America today, and this is what they're doing. So that is the difference of this case. It's 125 pages, but up to page 74, it is based on newspaper articles, on government documents, and uncontroverted facts that innocent civilians are being placed on this list. So you have to ask yourself, what for? Why?
What is the list called again? What's the legal name of this list?
The legal name is the Terrorist Screening Database. And what just jumps at you is that in the court's decision, they accept as true the word that the term that the government offered, which was data set, okay, data set, because in the eventuality that they are forced to show it, they just want to show like an Excel spreadsheet, except that in prior cases challenging the TSDB that have been filed by actual known and suspected terrorists, for example, Haiti versus Cable in Virginia, well, the attorneys were given the opportunity to examine the terrorist screening database in camera in the judge's chambers. This was not contemplated here, even though prior cases have contemplated it and have allowed it as part of the plaintiff's due process rights. So that's another deviation from what has happened up to this date in terms of these kind of cases.
If I may intervene, this is a really interesting switch that has happened in our case, that switch from TSDB to TSDS. And so TSDB stands for database and TSDS stands for dataset, terrorist searching screening database versus dataset. I haven't caught that moment when the defendants switched that language. I followed all their filings, but at some point that switch was made, because in the early filings, I know that they also used TSDB, and then that at some point they switched to TSDS. Do you recall, Anna, when it happened, and what was the triggering point?
No, in the first motion to dismiss, official capacity defendants motions to dismiss, they said the terrorist screening database is the term is used just as the terrorist screening is the data set, and that's not true. That is absolutely not true. Data set would be like a list of the people there. The database contains all the supposedly derogatory information, who nominated everything. Okay, and that is the list that not only do we are seeking access to, but that has been granted access to other people and other prior cases, such as Haiti versus Cable case. So they were going on and on with the mantra of the data set, but nowhere in the law does it talk about the data set. They always refer to the database, and that is what all the official legal reference talk about that. On the two motions to dismiss, they started repeating data set, just to, sort of like some subliminal messaging going on.
Okay, thank you for that clarification. I apologize for interrupted your exchange. Gary, please continue. This is your time.
I wanted to, this is related to the Patriot Act, right? The idea that you can put American citizens on a terrorist watch list legally. Is that where it came in?
In 2003, former President Bush enacted an executive order called Homeland Security Presidential Directive 6. It provided for the creation of a law enforcement tool that would be a list joining all the different lists from different agencies, and it was only supposed to contain known and suspected terrorists. That's the list. It didn't say, oh, you can put there people for other things, or no. Known and suspected terrorists, and there is something called the watch listing guidance that provides, even though they're really not very strict about, you know, the criteria, but it provides some terrorist criteria that you should abide by. The thing is that pursuant to the Office of Inspector General report 08-16, the FBI is sending, it found, among other things, that it was sending nominations to the terrorist screening center from the field offices. Were sending nominations without complying, and I quote, without complying with agency regulations. What that means is that they were placing people there that didn't really meet the criteria. They didn't bother to check if they met the criteria. Then this spring, we have had the testimony of all those whistleblowers saying that they were pressured to put the parents from school that went to school board meetings and other people that they didn't really think met the terrorist criteria to be classified as domestic terrorists. It is my belief that these whistleblowers don't have the level of security clearance to know that the insistence was to be able to place them on the program. But that doesn't really matter for the controversy we have in the court. What we have in the court is that there, by the FBI's own admission, there are innocent civilians in a terrorist database, and that's illegal.
Mm-hmm. Do you feel that targeted individuals are directly linked with that list as far as why they are targeted, or do you think that's a peripheral connection, or is it you feel like it's directly related?
Well, two of our plaintiffs have had experiences where they were told basically that they were known terrorists. I mean, they were suspected terrorists. Okay, and that's why they do have standing. And the judge sort of mentions it in her decision. One of them was on the ground with attacks to his ankle. He had a blood clot, and the sheriffs came in, deputy sheriffs, and said, ambulances out there, but we cannot let them in because we have to secure the area. We were told there was a terrorist living in the premises. He's an engineer. He's one of our plaintiffs. He has never had anything to do with terrorism, and he was only living there with his 87-year-old mother. And then the other one is Karen Stewart, who is a former NSA intelligence officer that had sort of a similar experience. She went to denounce the gang stalking, and asked the deputy sheriff at that moment was, wait, let me look for it. And what's your name again? Really? Oh, I can't talk to you anymore. And that was the exchange. So we have these plaintiffs have, why would you put innocent civilians on a list and tell police that interact with them, don't tell them they're on the list, but look around if you do a traffic stop or intervene with them, just look around to see if you find something, because that is one of the documents we submitted. It's the directive that the FBI gives to police departments across the nation. So yes, there is a connection, and the way that they get vigilantes hired by the fusion centers to go after targeted individuals is telling them that they are terrorists, that they are pedophiles, and that they are, a whole list of horrible things. So people, they send these people out on the streets to do organized stalking, and this is, it's a very sad situation where we are right now. One of the things that people need to understand is this was done for for the mind control of the population. And right now, the same technology that is being used against targeted individuals, which is the cell towers, are being used to carry out the directed energy weapons attacks because they are weaponized. They are used for subliminal messaging of the population. And that is an invasion of everybody's mind without a warrant, in my opinion, So this does not, the fact that cellular towers are weaponized and are being used for improper purposes is not limited to targeted individuals. It affects every American, every freedom-loving American out there. And that's why this message has to get out, because before it's too late. I think we caught it on time, and that's why we're doing this battle in court. But any freedom-loving American has to pay attention, because they might be targeted. You know, you wake up with what you think is fibromyalgia in the mornings and you feel like a little, you know, not yourself. It might be that they microwaved you all night and you didn't even know it, because that's why it's called no touch torture.
Mhm.
So people need to pay attention, and I hope you can help us spread the word that, you know, pay attention, because you could be next.
Can you share a little bit? I've heard of the fusion centers, but can you share a little bit more about what you understand those to be, and are they known, or is this something that is not like talked about in the public? Like, what are they exactly? Where are they?
Oh, I love your kitty. I'm sorry. Oh,
Oracle.
oh my God, is that like 18 pounds? Oh my God.
No,
How
he's not 18
photogenic.
pounds. He's probably like 12, but he's bigger than both. He's pretty big. There's
Oh, precious. God bless him. Well, the fusion centers, I really urge you. There's an entity called the Brennan Center for Justice that is affiliated with NYU School of Law. They did recently an awesome study on how fusion centers are nothing but organizations, they're 99 around the nation, state organizations created to violate people's civil rights. They don't even have a statutory authority. They are mostly funded by DHS. And in Oregon right now, there is an ongoing lawsuit, which is, you know, very interesting. You should look it up, that they're challenging the legality of the fusion center there, because they go after people in ruthless ways. Okay. In the case of targeted individuals, they are the ones that are in charge of doing the breaking and entering into the houses. They move your furniture around, they break your, you know, they tear your clothes, they stain your clothes, they break your favorite coffee pot, things like that. And they do also, you have also the InfraGard that, at least here in Houston, they do the electronic surveillance, all of our communications, you know, like what happened to Len with the hacking of his email accounts. All of our communications are severely interfered with fake, you know, it is my position, illegal FISA warrants, because FISA warrants are only supposed to be obtained against foreign citizens that are involved in terrorism, right? Or in activities in furtherance of terrorist activities. And the FBI has been known that has been abusing its access to the FISA court, and that's exactly what's right now before Congress, limiting that authority, because a lot of, you know, hundreds of thousands of innocent Americans have been illegally, their communications interfered with by these rogue agents and operatives of the government.
Is there a meaning to fusion, as in fusion center? Is it involving some type of computing system, or what does that mean exactly?
What it means is that they have state and federal agents working shoulder to shoulder in the supposedly counterterrorism efforts.
So it's just the word, you're fusing the information together across.
And the agents, and then when you look at because I placed one of those fusion center agreements in the record, on the record, and it's basically, there's FBI agents stationed there, there's DHS agents stationed there, and they pretty much, their procedures are controlled by DHS and funded, and the activities are funded by them. Now they're doing it through grants. Before it was more direct funding, but basically they control, and it's all supposedly under the guise of counterterrorism. You know, we do not have the terrorist activity in this nation to justify these 99 fusion centers, that what they really do is go out after innocent Americans and make their lives a living hell.
The fusion centers are organizing the gang stalking, as far as your understanding.
That is correct. That is, they are organizing, they're funding it, and I don't think that their activity is not even 1% legitimate. I really urge you look at the Justice Brennan Justice for Center report. It is scathing, and it is very well researched. ACLU has also looked into their operations, and it's just a rogue abuse of people that are helpless, people that are really abused by the system. They should not exist. Just local sheriff's offices, and the fusion center should definitely be eradicated, because they are the part of root of the problem.
Yeah, I wanted to ask both of you if you have heard of connection of the LHC, the Hadron Collider systems with this mind control idea. And I haven't looked into it a whole bunch, but I remember I saw one self-proclaimed TI that he said, this thing is going to speak through me. And he did like 15 minutes. And of course, it could be made up. It could be, contrived. I don't know. But he said the being, or I think it was some sort of AI or even an operative that was working like inside of the Large Hadron Collider, or one of the CERN units. The guy there said basically that's what CERN is for. It's mind control, like large way to promulgate this. Have you heard of anything like that?
Well, I don't know if Len wants to address it, but I can tell you this much. There are two things going on many things going on, but they're all being administered from the United States Space Force in Schrevers Air Force Base. That is the only Space Force base that doesn't have a landing area. It's all underground, and they have the most powerful computer in the world. And they are the ones that fire the microwave weapons that are located in cell towers that are weaponized, 4 panels in the same direction, looking in the same direction, with with a chip that was patented by the Ericsson Corporation, which creates microwave beams. This chip is not necessary for the transmission of voice and data. That is how they carry out their microwave attacks. One of the versions of these attacks is what you're referring to, which is the auditory effect, microwave auditory effect, also known as voice to skull. That can be done in a myriad of ways. With Adobe Voco, they can take the voice of a friend of yours and have them whisper, horrible things to you. It's a 24/7 torture. That collider has nothing to do with it. This is all sponsored by American taxpayer money. Is torture paid for by taxpayer dollars in these black projects, and this has got to stop. The other thing they do, which is remote neuron monitoring, it's also a patented technique, and I'm not gonna go into it because it really sounds like science fiction, but it's not. Now it's all coming out in the open, how they can remotely actually read your thoughts and do a lot of affect your emotions. But the subliminal messaging that is going on is being done through these weaponized towers, and that's what affects every American. I mean, I don't know if you took the jab or not, but no. I really believe that the people went like sheep to take the jab because of this subliminal messaging. It was 24/7. You're gonna die. Go get the vaccine, because it's just not. There's just no other way how to explain it. And without entering into political correctness, let me give you an example. This past week, there was an article that 40% of students in Brown University identified as either gay or trans, or I don't know, 40. Exactly. And, I was talking to Richard Lighthouse, who is our expert here in targeted justice, and he says that can only be attributed to subliminal messaging.
Mhm.
It's not that they put something in their water or their food. No, no, no. This is about subliminal messaging.
The normal range is like 1 to 3%, 1 to 5% or something like that.
It's huge. It's huge. I thought it could have been up to 7. I don't know, but 40% identify as either gay or bi or trans. Or I mean, look this article up, because I was in a state of shock, and we both came to the conclusion. It's Brown University. It's about subliminal messaging. It's affecting all Americans. It's interfering with your capacity to have your own judgment, and that is part of the world governance that they are heading to, that you have to think as they tell you to think.
Wow, it really is 40%.
You found it?
Yeah.
I'm telling you, I don't speak lies. I tell you, when I speak, I try to speak the truth as most as possible.
Yeah.
So,
Yep.
and that is a prime example that it has got to do with subliminal messaging.
I mean, these people have to be also, I mean, you use the word sheep, but I don't know what the correct terminology. I call them NPCs, like they're just robots running around everywhere. But if you have a remotely decently strong sense of self, even if something is whispering in your ear, hey, Gary, you're gay, I'm not going to just be like, oh yeah, cool, I am, I must be, because the voice told me I was. Like, it's like the people have no willpower whatsoever. If you're going to somehow get half of them to turn into whatever version of LGBTQ, ZY, whatever, then it has to be like they don't have will anymore.
1/3 of the population is highly suggestible. That's enough to sway an election. That's enough to have that 40% number. 1/3 of the population doesn't have that, what you say, that it's a sense of self, or like these very firm convictions that don't let them. Let me give you an example. As I am a targeted individual. I am an attorney. They tried to entrap me into committing so many crimes and so many ethical violations, and I always stood and I didn't know I was targeted. And I always stood my ground, and those values that my parents ingrained in me, even though I was in terrible situation, they came through and held me up. And that's why they weren't able to put me in jail, or take away my title from me. So you have to have firm convictions, and today you can see not many people have that.
No. I feel like it's I feel like this world, this realm, and that's up for debate as far as I'm concerned, as far as where we actually are. But number one, it's some sort of clown show that, like, on the political level, it just makes no sense whatsoever. And number two, the power structure itself seems to operate under like a narcissistic spectrum output. Like, it's gaslighting people. That's the way that it gets people to try to listen to it. It gaslights them, it scares them, it threatens them, intimidates them. And then if you add like technological weaponry such as directed energy weapons or whatever you have, it's just like an enhancement, a complement to the thing trying to intimidate everybody. That's what it feels like to me. I don't even feel any I don't feel like a person out there is like, let's target all these people. I feel like it feels more like a technological intelligence to me that's organizing this. That's what it feels like. I don't know for sure, but like, people have emotions and they have weaknesses. They're fallible. This like presentation and the fact that it has been swept under the rug for however many years, like, you guys are still trying to get it to be believed on the world stage, and you're still having lots of difficulty however long it came after when did this first start happening, as far as who was the first complaint?
Well, this program is really a fusion between MK Ultra, which happened in the 50s by the CIA, these mind control experiments, and COINTELPRO by the FBI, which was a Stasi program by the FBI. They fusioned them into this program. So there are people that have been targeted way before the Homeland Security Presidential Directive 6 was issued in 2003. I believe the oldest TI the Targeted Justice knows of dates back to 1989 or 92, something like that. But it has gained momentum. Please bear in mind, there are more targeted individuals outside of the United States. Our estimates based on the numbers that were produced in the El Haiti versus Cable case, there's like 6 million people around the world. And outside of the United States, they suffer incredibly. I urge you to look at their videos, Viatech, Ikator, those pages. They have videos, and because it's really much more ruthless, the attacks there, and people don't dare say anything because they will be put in a mental hospital automatically. So, here it's taken decades. That's why I'm so hopeful, because we are achieving a unity in the community, because the goal is to divide, to disrupt, to divide, so that the targeted individual is lonely, it's alone, and nobody believes them. And we are accomplishing a unity in the community to be one solid voice that will knock on Congress doors and say, you have to stop funding this. American dollars cannot be used for the torture of innocent civilians here and around the world.
I want to clarify my own statement that I feel like it's artificial. I'm not trying to insinuate that there are no human operatives involved. What I'm trying to say is that my feeling space regarding the overall intellectual structure of how people are targeted, why, when, etc., that to me feels artificial. I'm sure that there are people, of course, involved. And I also wanted to ask, so say you are targeted one day, you wake up and you feel targeted. If you run to the hospital, if you run to the police station, if you call your mom or dad, like, are these all co-opted in the sense that you're mostly going to meet with, you are crazy, like as far as mental health, if you went there, is there any group anywhere that would treat you as anything other than insane?
My experience, I can tell you, it's only in targeted individual groups, because even good people, for example, I had a doctor and I point blank asked her, you believe me, right? And she said, yes. Then when I called her again for an appointment, she was never available, because these are criminals, blackmail, intimidate. They will take away your license. They will damage the electricity in your house. They will do horrible things to people that help targeted individuals. So in the gang stalking manual, it is prohibited. They are prohibited from helping you. People are prohibited, and they turn your family against you. So even your family doesn't help you.
But there's an actual manual, like, is it available?
Yes.
Yeah.
But in the Targeted Justice webpage, you can see one that was obtained from a European source. There is, for example, and the way you know that there is such a thing is because the tactics they use, now targeted individuals, that they get together in these conference calls, and I urge you to get into one, so you listen in to the pain, to the suffering of innocent people for the sake of this heinous experiment. So they use the same tactics. For example, I would get 3 flat tires in a year, and the same goes for most targeted individuals. They jack with the electronics in your car, in your house. They come in and move the furniture. It's just, it's like a pattern that they do the same things. To targeted individuals, they just do the same things, not counting the physical attacks, which are, they vary, but they have a common thread. So yes, there is a manual, and they are prohibited from helping you. They are prohibited from giving you a glass of water. I mean, that's how bad it is.
How much do you think, how much involved is your or TI reactivity factor as far as whether it keeps happening, how it happens? It's like, say you're acting as a Buddha and you have no reaction all the way down to your internal, very deep core of yourself. Are you going to still be targeted, or is the thing gonna, or the person going to look at you and say, well, that's like me trying to target a rock and there's no point and I'm moving on?
Well, I can tell you, you will continue to be targeted, because the point is, they do these things to make you think you're going crazy, or you know, and I can talk from my experience. You know, I was targeted for over 23 years before I found out I was, and it's because it became so bad. But like, bad things happen to me, and I'm like, well, that's my life, you know. But I did hear, I don't know if, you know, from hearsay, that there was this one target that he really went along his life and bad things happened and he went along and he, you know, stopped being targeted. I don't know that for a fact. I do think that people do, when you just focus, you know, what you focus is in, when you get bad, what you resist persists. So what we're trying to do is to have an optimistic outlook among TIs. And it's very hard, because some people are attacked in ways I cannot tell you, that are atrocious. If you want, I can privately tell you about them, but they are atrocious. So it's very hard sometimes to say, okay, I'm going to forget about it, I'm going to put it away. But certainly that is what we're aiming for now, that they put it aside so that we can engage in the activism that is going to bring this down. Because not just a legal case suffices. We need the pressure in the press, in Congress, in different arenas, and that's why the community needs to be together and you know, muster the strength from within to do this.
It's very interesting to watch, because I'm a part of some groups, like a few TI groups on Facebook, and I mean, half of them seem to be agents, or a certain percentage of them seem to be, or it's just they themselves are, you know, listening to the whispers that their fellow TI is a perp rather than you know, a TI, and then they start attacking each other and it all falls apart really quickly. I feel like the groups have been infiltrated quite successfully. That's COINTELPRO, right? Is infiltrating groups. That's perfect.
Exactly. It's like the Stasi, and that you hit it, the nail on the head, because that is what the criminals do to divide the community, to plant suspicion among each other. And most TIs have a severe case of PTSD. PTSD, no PTSD, PTSD. And it is because this is really, can be really debilitating. Let me tell you, 66% of TIs have V2K. That's 24/7. You know, there are ways to minimize it with the bone conducting earphones. They're called shocks, aftershocks or something like that. And if you put white noise into them, you can pretty much cancel them out. But it is a very debilitating situation. It's the type of torture. So people, you know, we have to be tolerant of each other, but it's easy to say and hard to do for people, because I know that they undergo incredible torture.
I feel like this is almost bigger than it seems on the surface. I feel like it's very intricately linked with the power structure as it sits in this reality, which is why you're having so much difficulty trying to bring it to light, because it's built inside of it, that the self-defense mechanism for it is built into people's trying to talk about it. So it's you're almost fighting against yourself by trying to call attention to it in some way, but also you can't do nothing, right? It's very interesting.
We have accomplished a lot, I believe, just bringing just the filing of this complaint and the creating of the awareness and the uniting of the community is a huge accomplishment, in my opinion. We need to get the word out more, because I know that Americans will be outraged to know that their taxpayer money is being used to torture people and to illegally classify them as terrorists. Their lives are stolen from them, literally. And it's just the government criminals have been, I'm sorry, this is so dear to my heart, because the government criminals have been intimidating and press. They either block our emails and our communications, or literally, like I had a journalist who confirmed an interview, and she stood me up, and she didn't even apologize for it. So whether it was mind control, whether it was blackmail, I don't know which one it was, but it's just, it defies the basic precepts of, in that case, politeness and professionalism. And also that this is the most important case that has been filed in decades, important for the United States. And the reason is the three defendants, main defendants, are the three that got impeached, that have articles impeachment pending: Garland, Mayorkas, and Ray. The information in this complaint comes from official sources. This is not that I made it up. One important detail is that 97%, and this is going to blow your mind, 97% of the people on the terrorist screening database are not known or suspected terrorists. They don't meet the criteria. They are non-investigative subjects. And you have to wonder, how come a list created for the listing of known and suspected terrorists is 97% of it is composed of non-terrorists?
So what is
You
the
have to ask yourself.
criteria then?
Huh?
What is the criteria? Is there known criteria for that 97%?
Samuel Robinson, a deputy FBI director, appeared in this case and said that they are there, placed there under secret criteria. I am not kidding you. He put it under penalty of perjury that they are there for secret criteria.
Wow.
So that's what, that's why we have hope that we will succeed in our appeal and targeted individuals, because what we sought was a national injunction to remove the names. We're not challenging the entire list. We are requesting the removal. I think it's perfectly reasonable to ask for the removal of the names of innocent civilians that don't meet the reasonable grounds, suspicion, or probable cause to be on that list, because only 0.29% of the people on the list, pursuant to a Department of Justice audit report of the Terrorist Screening Center, only 0.29% meet the terrorist criteria. So the rest have to be removed from there, because this list is disseminated throughout the nation with false information that over 300,000 Americans are suspected terrorists.
I wanted to ask, these three people you named, one of whom is Garland. Who are these people? What do they represent, and why are they the ones being sued versus like the three-letter agencies or something?
Well, Garland is the Attorney General. His job is to supervise the FBI operations, make sure they comply, among other things, make sure they comply with the law and with the Constitution, and that no civil rights are violated. Aside from that, when people have made complaints to the FBI about their organized stalking or the directed energy weapons, FBI would be the only agency with the authority to investigate that. They have been dismissed as mentally unstable, and the United States Department of Justice has refrained from believing the victims. They allege they believe the victims, but in this case, No, there's no believing the victims. In fact, the DOJ in this case came to the court to say that they are delusional that with fantastical allegations and conspiracy theories. The same Department of Justice that is supposed to defend innocent Americans illegally placed on a list. That's number one. The second one is Christopher Wray, who is the director of the FBI. He is responsible. He is the one that has the ultimate say in the policies of placing innocent Americans on a terrorist list that they shouldn't be there. And also Charles Cable, who is the director of the Terrorist Screening Center that is in charge of the preparation and maintenance of this list. Alejandro Mayorkas, he is the director, the secretary of the Department of Homeland Security, and Kenneth Weinstein, who is his undersecretary for intelligence. These two have been brought in their official and personal capacity because they are the ones in charge of implementing the policies on the fusion centers that go out, and pretty much send out vigilantes against innocent Americans that are illegally placed on the list to stalk them and to harass them. So those are the 6 persons that are officials of the United States government, aside from the Department of Homeland Security and the FBI that were also included because they disseminate the information in violation, the false information on innocent Americans pursuant to the Privacy Act.
What about I know, Len, you had a doctor verify that you had actual physical effects from this. How does that tie into the court proceedings? And will they recognize that as evidence, or do you not know yet?
Well, my personal case is such that I do not know if my name is on the TSDB because my request to the FBI was returned unanswered for the reason of national security. However, I am diagnosed with Havana syndrome, or the medical version of it. It's quite complicated, but I was diagnosed by the same team that diagnosed U.S. personnel returned from Cuba. So I have the same kind of vestibular damage, which is a hallmark of Havana syndrome. We also recently seen a shift in terminology because Robert McCreight, somebody who advises NATO on the emerging technology, proposed this term in 2021, neurostrike. And that is a much more fitting term that describes the attacks inflicted upon the victims of this technology. So Havana syndrome would be, if neurostrike is a version of concussion, then Havana syndrome would be equivalent to MTBI. So that's the sort of the framework. But the Havana syndrome is not a medically recognized, it's not in the classification of diseases. It just goes under brain injury other. But the military has, it's in their classification, it's called UBI, unconventionally acquired brain injury. And it talks about directed energy. So to conclude, I have I'm formally diagnosed. My case have been forwarded to the DoD by the neuroweapon expert, but I do not have any information whether my name is on the terrorist searching database because I have been refused that answer. However, people with similar experiences have been told that they're on the terrorist screening database, and that's the legal theory in this case. This is what we're trying to prove. This is the the most plausible theory that we have to connect these atrocities with people being listed on this database.
It's kind of like astounding that this can be so big and yet so far successfully everyone's written off as psychopath or schizophrenic or whatever. So that's very surprising to me that has gone this far. But I wanted to say, if Havana syndrome has been recognized as being real, right, and it is on some level, it has been recognized as being real on some level, right, then how can the court look at your case and say they're making it all up because the precedent has already been established? So why does that work? I don't understand.
Well, allow me to tell you that one of the allegations in the complaint is, particularly in the context of the Havana syndrome, is that the National Academies of Sciences and Engineering issued a report concluding that Havana syndrome is caused by directed energy weapons. That study was cited in the complaint, and even though we did cite it, the court still placed between quotations the term directed energy weapons as if it was a fictional concept. So there is no other cause of Havana syndrome other than directed energy weapons attacks. And the CIA director admitted on TV that no foreign power was responsible for the Havana syndrome cases in the embassy. That only leaves one culprit, and that is the United States Space Force operating these weapons. They not only use cellular towers, but they also use satellites, Lockheed Martin satellites that track every single human being on Earth. I am creating the awareness that a lot of people have the artificial tinnitus, that all of a sudden you hear it, and you didn't have that before. And what that is an indication that you're being tracked by these GPS satellites. There's also Mercator weapons on these satellites, some of these satellites. And so they're, like you said, it's too huge because there's a lot of people making money off the torture of innocent civilians, and this has got to stop. We need the American public to be aware of this and help us stop this monstrosity. This is not invented. Nobody, you know what? Reality exceeds imagination in this case. Mm-hmm. You cannot make this up. When you hear the stories of the real TIs, there is no outrageous imagination that can concoct the reality that many TIs live.
Yeah, there's, like, Len, when you were asking me earlier, how did I go from possibly being a skeptic to believing? And I would say I don't think I was ever an actual skeptic, and that's only because I witnessed how this reality operates and the power structure, and it always operates in the same exact way. And that's to put the fingers in the ears, close your eyes. No, I can't hear anything. Like, you just run and hide and pretend nothing exists. And therefore, anything that makes a modicum of sense, and there's some evidence for it, then that's likely to be the case. Like, science fiction books are more likely to be closer to reality than whatever comes out on CBS or NBC or any of these stations whatsoever. And the pendulum has swung so far, in my mind, to where they don't really talk about anything anymore as far as mainstream. It's complete empty nonsense. It's like the economy and it's gone so far that there's nothing is actually talked about, literally nothing. And then if you want to find some substance in the information, you have to go find, like, my channel or Len or a few people who have somehow escaped that monstrous. It's like the nothing and the never ending story, right? It's this oppressive force that just, like, rolls over everything. It's silenced and turned most people into sheep or robots. But the few percentage of us that aren't that, we still have to live our lives. We still have to be able to, make intelligent decisions and support ourselves financially or emotionally, spiritually, all these things. And it is difficult. Like, I'm not a TI per se, but I have to live here in this reality, and the whole thing is oppressive as far as I'm concerned.
My last question to you, Gary, the question that I've been wanting to ask for a long time. You're someone who has a an analytical mind. You're an avid chess player, which tells me a lot about people's a person's intelligence and cognition. You also describe yourself as a fan of so-called Occam's razor. So my question to you is, do you think it is prudent to apply Occam's razor to something like a targeting phenomenon?
I would say only in the sense of reducing your own personal overwhelm. Only in that sense. I'm not saying ignore any of the facets that are presented to you, but if you realize that this situation is very large in terms of power structure and reach, very, very, very large, if you try to take all the stuff, like, it'll blow you over and you're gonna go cartwheeling down the road. Like, you can't do that. So Occam's razor just says the efficient path is the best path. Like, if you can go straight from point A to point B, do that. Don't take a bunch of detours. So that's all I'm saying. Like, when I say I live by Occam's razor, I don't add lots of extraneous fluff in my movements. I just go to the point, unless I'm trying to, be chaotic and random, which has its uses also, especially in terms of targeting. If you can keep your mind, flying all over the place, it doesn't give these things have physical hooks. I feel like when they're targeting minds, not only do they have to get the thumbprint, so to speak, in order to lock on, it's also trying to hold you in place. So if you can keep your mind like chaotic and keep your emotional volatility level below a certain threshold, and that's something that you can work on, like you can work on not being reactive internally like that, then you basically fly under the radar.
I would like to add that, as to me, the Occam's razor does not apply to a targeting phenomenon simply because there is an intelligent agent behind this phenomenon. So when you look at, something natural that does not involve an intelligent agent, it is easy to say that, okay, well, if I have a puddle of water, then it came from somewhere, and then you look for a source. But that does not involve any intelligence. In case of targeting, not only an intelligent agent is behind it, it's an intelligent agent capable of deceit, misinformation. Moreover, it's an intelligent agent that has been studied human cognition. And so therefore, it can utilize your personal cognitive and emotional vulnerabilities. So for example, when you're saying, here's a targeted individual and he goes to, or she goes to the relatives and the friends and then describes the situation, the first thing that comes to their mind is something psychologically or psychiatrically off with this person. That is a typical Occam's razor. And if you understand that this Occam razor has been weaponized to take advantage of these people's thinking, then you will understand that under no circumstance Occam's razor could be a useful tool of cognition to understand this phenomenon, because of what I previously said. Does it make any sense to you, Gary? And do you have any comments?
Yeah, that explanation does make sense. And I think that idea can be applied across the board to how people's minds work nowadays. And I was talking about this recently, thinking about it recently, in that the aware people, the so-called aware community, not woke, but like people who still have cognitive function, and that's not a whole lot, but even those guys, especially those guys, they have mental boxes, gut reaction responses to things, and they will say everything is a psyop, everything is controlled opposition. And even if they don't go so far to do blanket statements like that, to you, those terms also have all been weaponized. Every single one of them is weaponized. When you say it's controlled opposition, the chances that you are saying something useful is less than 10%, maybe, in my mind. It's like, we have to retool our language even to be able to actually get at the thing, because the mind control is so, like, it's in every neuron, basically. Like, it's sitting there waiting for you when you have a thought about anything to swoop in and say, oh, this is just that. And yes, that gut reaction response, if you can term that as Occam's razor, then yes, it's not correct. And again, that's not what I'm saying. Like, I'm saying for myself, Occam's razor, my mind holds vast amounts of information that I don't even want to have. Sometimes there's too much information. So for me to stay sane while I'm navigating my own mind field, I, condense it down to something simple and something that I keep the pointers to the baskets of information. And that's what I keep present on consciously, the surface of my mind. And that's Occam's razor. It's like, I navigate the surface of the ocean via these little markers. And yes, those markers can be tainted and co-opted, and a lot of them are. But if you know about that, then you're not picking the co-opted indicator, is what I'm saying.
All right, fair enough. I understand your point very well. Well, we're coming. Our show is coming to an end, and as usual, we would like to hear your words of wisdom, or your whatever's on your mind. Ana, you go first, please.
Yeah, well, you know how you say, what are we going to say was the topic of this show today? And I have to say it's the miracle show, because both you and I assume, I perceived from you that it was a physically difficult day, and it was very difficult for me too. But when we set our minds to accomplish something, we muster the power to do anything, and that's a miracle. And that's why I want targeted individuals to, I know it's very hard, but muster the strength that you have within, to help us all beat this monster.
Thank you, Ana. Gary, how about you?
Well, I kind of default to the position that, like, that's what I do. I try to, like, go way back to the beginning, the Big Bang, whatever, like what spawned everything. And I always come to the conclusion that we're all some form of God particle playing games on some level, in some sense. And with that as the basis of realities, of multiverse, you're going to have really bad situations, you're going to have really good situations, you're going to have trap situations. And keep this in mind, if every single being that has a sentience is a God particle, okay, to start with, then they have equal power across the board, okay? There's no one that's more powerful, no one that's bigger, okay? So if you remember that, the way to beat a fellow God particle is to convince them that they're a little piece of dirt, they're not worth anything, they're weak, and so on. And you apply that to targeted individuals. How are you going to operate within that game set? You're going to intimidate, you're going to bully, you're going to tell people they're worthless, all the things that you see, you're going to gaslight. So just remember, like, at the very base, you're just as powerful as anybody else. So you just have to figure out how to, like, pull that, and you'll be fine.
I understand, Gary. Those are words to really digest and think about it, and it definitely offers your unique perspective. You don't think like everyone else, and that's one of the reasons I wanted you to be on the show, to give your unique perspective. As far as my thoughts about this week, this is sort of a great reset for us. We have been kicked out of the Texas court. The judge said, I'm dismissing you, and most of your claims I'm dismissing with prejudice. But when I'm reading her decision, certain things just don't sit with me. One of the things is when she refers to directed energy, she puts it in quotation marks. Why? Directed energy is in the budget. Directed energy weapons are in development. Neurostrike Chinese technology is operational, and we have a judge who are just technologically uninformed, making these decisions and putting quotation marks around directed energy. Well, if that's the case, maybe we should put quotation marks around the word money when we pay for this directed energy. It's just inconceivable. But nevertheless, let's not look back. Let's look forward. Louisiana, Fifth Circuit, here we come. And we will be continuing covering this extraordinary lawsuit, TJ v. Garland, until all targeted individuals are free. See you next Sunday, rain or shine.